everybody. And I know we are nearing the lunchtime. I'll keep my presentation short. The thought that Anshul left us with really transitions nicely into the topic that I have, which is navigating IP ownership issues. But before I get into this, just to tie it up with the Make in India and startup policy, yes, there are a lot of schemes that have come up, a lot of policy initiatives that are being taken, which I'm not going to touch upon here, but I'll be happy to discuss them later during the break or lunch or any other time. And one important thing that I just would like to mention here is that the startup scheme is available not just for Indian startups, but even foreign startups who qualify certain conditions and can then make use of some of those initiatives. So foreign attorneys, anybody who's interested in looking at some of the foreign startups also making use of these schemes, please feel free to get in touch with us. Now, coming back to the point of navigating IP ownership issues for startups, definitely nowadays IP is a buzzword. A lot of startups are more aware of IP now than they were ever before. And they do come to us saying that we've created an invention, we would like to protect it, we would like to commercialize it, what needs to be done. However, many times they do not understand that things like the paperwork that they keep to the last minute can actually end up harming them, can actually create issues in ownership and then commercialization going forward. So I have just 4 slides and certain experiences to share based on each one of those 4 scenarios. First is when you have the IP created by the startup themselves, how do they resolve certain ownership issues? So for example, a founder may create certain IP even before he has actually started the company. There's no startup yet, there's no company that is registered yet, but there is IP that the founder has created, and maybe they have filed a patent application in their own name, and then they register a company later. They need to transfer the IP rights to the company, they need to get that registered with the patent office. How do they navigate all that? Sometimes what happens is the founder has filed an Indian application in his name, but then they want to file, say, the PCT application in the name of the company, because that is where the investors are looking at having the IP owned by the company and not by the founder personally. But there can be issues of claiming priority if both the applications are owned by different parties, the founder being a separate entity from the startup created by the founder. So these kind of things are something that they really have to look at. Second aspect could be where the employees are the creators. So we all know that while a lot of people would like to work with startups, we also, particularly in India, have a problem of employees moving across companies, across startups. Supposing an employee has contributed to an invention and then moved on, how do you make sure you do not have to go around chasing that employee to get the assignment agreements, the declarations, all the other paperwork done? So what are the things you need to keep to make sure is done right from the beginning so that later you do not have a problem? So getting the assignment agreements, making sure the employee agreement has a relevant clause for that. The other aspect can be external collaborators. Now, many times startups, there's a lot of serendipity involved in even creating a startup. Sometimes you have these hackathons that are there, and 2 or 3 people get together and they have a brilliant idea and they think, okay, we should go on there. And there may be other collaborators that may give them ideas. There may be mentors, there may be professors from universities, somebody is doing a PhD thesis, and out of that comes a startup. Who are all the people who've collaborated? Who all need to be identified as inventors, as owners? And how do you make sure that the ownership actually finally rests with the startup and you do not get into problems later on? So that identification part that many times is not done very rigorously initially, and then it becomes a problem later on. So we had this case where a startup had actually worked with a few professors from universities from outside India. And then when they went on to file a patent application, they realized that they would have to get an NOC from the universities so that they can have the patent applications filed in their names, and getting that NOC delayed their whole patent filing process by over a year because the universities had their own IP policies. They could not allow the startup to own the IP by themselves, and there was a lot of paperwork that went to and fro, which could have been avoided had they initially thought about it and decided that the collaboration would happen in a certain way. Similarly, with the employees, like I briefly mentioned, there have to be non-disclosure agreements, NDAs, so that if they move around too much, they do not take your IP with them. When you have independent contractors, when there is work for hire, how do you make sure that the IP rests with the startup? And how do you safeguard? So there can be trade secrets. A lot of startups start off with trade secrets before they actually get into the patent filing stage or any other kind of IP protection stage. So safeguarding those through, again, more of contractual measures. And yes, assignments, making sure that they are registered in the name of the startup and not the individual employees or inventors or even the founders, but making sure it belongs to the startup. The other scenario is where IP is out-licensed. So a startup has created IP, but they probably are not in a position to manufacture it or commercialize it. They want to out-license it. So should they have an exclusive license or a non-exclusive license? Should it be jurisdiction-specific? So we had a case where a startup wanted to manufacture and sell in India alone, but they knew that there were commercialization possible in a lot of other, particularly Southeast Asian and African countries. And what they did was they licensed it out only for specific jurisdictions and to different companies for different jurisdictions. So that was a very interesting strategy that we went through with them as to how the IP for different jurisdictions could be monetized separately, maximizing it in every jurisdiction that you have. Field of use restriction, so supposing an innovation has applicability, say, in oil and gas and as well as solar, as well as wind power. So how do you make sure that you license it out with different field of use restrictions as well? So even within India, you could have different licenses with different companies and make sure that they each operate individually in their own fields. Of course, the licenses will have to be registered with the IPO. That is the Form 27 issue, which I'm not going to go into, but then licensees also have to file a working statement in India. And there are definitely tax and other implications that have to be taken care of while they are looking into all this. Next is in-licensing of IP. So supposing a startup has certain IP, but they need to also license in IP from other collaborators, then how is it that they're going to work on that? Can the startup also sub-license it to somebody else? Who is going to own the improvement? So supposing you have taken a license from somebody and you're working on it, commercializing, there will be improvements, there will be further innovations down the road. Who is going to own them? How are you going to share royalties? So all those are aspects that startups need to think about. Sometimes in a hurry to just get into the commercialization deal and make sure that they start earning revenue. Some of these things are not put into place initially, and then it becomes a problem for them later on. And of course, validity check, the example that Anshul had given, that when you are in licensing something, but it's not a very strong patent or not a very strong IP right, how do you make sure that it is enough for you to actually make a profit out of it? The final scenario is joint development of technology. So are you going to then share the ownership, or are you going to have it exclusively? Who can sub-license? Can each of the parties sub-license it separately? Or do they have to actually work together in sub-licensing it? Is there any field of use or jurisdiction restriction on each one of them? And delineating what belongs to each party. What is it that each one of them have brought to the table? And to make sure that if something goes wrong with the deal, that they go back with their respective IPs without feeling cheated or without feeling that the other party has taken advantage of them. And of course, safeguards against IP leakage by respective employees. So these are some of the critical issues that when startups talk about technology development, technology protection, and technology commercialization, they need to look at this whole variety of concepts. So it's not just about strategizing the IP protection, the types of rights, whether it's patents or trademarks or designs or trade secrets, but also looking at these strategic commercial aspects and the contractual aspects that are necessary to be able to monetize the IP. So I will just leave you with this thought.